Well, thank you. Really appreciate being out here in Ray today and in the Republican Basin. I think a lot of folks in Colorado don't know where you live or who you are. Is that right? You know, we're always looking to the mountains, like those who came out and explored this great land. And I'm just glad to be out on the high plains today. The 1/3 of Colorado that was the entryway for most of us. And that was quite a ride in that moonlit night last night, coming across Highway 36. Not too many folks behind me. I was able to get out of the car and I waved at a couple of hawks that were coming across the road and saw that big orange moon coming up. The worm moon is what my son Daniel, who's a farmer outside of Avondale, irrigates off the Bessemer, and he's so excited this morning because the water's in the ditch. And there's nothing like it, you know, when you open up that lateral and you put the siphon tubes in and you get it down the furrow rows, and the working and the singing water just talks to you about the coming spring and the summer and the fall. Now, some of you are dryland farmers. How many dryland farmers do we have? You guys got guts. That's the hard way, right? But, you know, Colorado and water and our obligations to downstream states is what I'm going to talk about today. But I'm going to talk a little bit about our history and culture. Thank you so much for the sponsors that acquired from the Colorado Foundation for Water Education this great Citizen's Guide to Colorado's Interstate Compacts. Take it home, refer to it. It's almost out of print. I hope we can get a reprint. So you timely got the last remaining issues before we have to try to press the button now and try to figure out how to get it reprinted. Maybe update it a little bit, Dick. You know, some of the Republican River events that happened since we put this guide out. So the inset map, there it is for this great guide. By the way, Emma Jordan of Briggsdale, Colorado, is the designer of the Water Foundation publications. He does such a great job. We have 9 citizen guides. The first guide published by the Water Foundation, by the way, it was established by the legislature in that horrendous drought of 2002-2003 to communicate with Coloradans about all aspects of Colorado water. So there's the Citizen's Guide to Colorado Water Law, which you can also obtain from the Water Foundation. The website is on the back of the page here, on the back cover. There are 33 Headwaters magazines that can be downloaded, 9 citizen guides that can be purchased. The next Headwaters magazine, we publish 3 Headwaters magazines a year, will be about the Northern Colorado flood. And then for the fall issue, we're looking at doing an Eastern Colorado issue. We've never really focused on the plains. For the reason that I just said, we tend to forget about that. We look to the mountains, and we look to the canyons, and we look to the mesas, and we forget about this great region of eastern Colorado. So we're looking at doing an Arkansas, Republican River, South Platte, High Plains issue of Headwaters magazine for the fall. So we'll probably be coming out for some stories, and man, do you folks have some stories to tell. I heard some of you lying about your age as I was standing getting the coffee. Something like, you look younger than you did yesterday, things like that. I like this Ogallala aquifer map here, and you can see how much we're wedded to our adjoining states in the management of this scarce and precious groundwater resource. So 9 interstate compacts. Colorado's water reaches to the Mississippi River, to the Gulf of Mexico, to the Sea of Cortez. 18 downstream states depend on water that comes right off the Continental Divide, and some water contributed from whatever outcroppings there are that give rise to this mysterious Republican River basin that kind of springs out of nowhere and goes into Kansas twice and Nebraska in between. What a basin this is. Probably very unique, maybe in the whole of the west about the way this thing operates and the dependency of a great rural economy on the use of this water. So this compacts guide breaks out each of the 9 interstate compacts, explains some of its history and features. So what is a compact, and why are we the great compacting state? A compact is an agreement between states that share an interstate stream basin. So upstream and downstream states, when approved by the state legislatures involved and ratified by Congress, it then becomes the law of the land, the law of the states and the United States, sharing the interstate stream water. Now, this arose out of a case between Kansas and Colorado that was filed in 1902 in the United States Supreme Court. Now, the Supreme Court of the United States has original jurisdiction over disputes between states. And this unique water dispute was filed by Kansas, which was claiming that Colorado, its developments in the 1860s to the turn of the 20th century was depleting water that Kansas needed for agriculture. Now, generally, Kansas agriculture came along after Colorado agriculture, especially use of the waters of the Arkansas River. Now, Kansas was part of Colorado, you have to understand, right? We became a territory in 1861 at the outset of the Civil War. Can we get, there we go. Let me get back to this. Go this way. Okay. Now, Colorado was formed out of 2 great treaties. The 1803 Louisiana Purchase that came up the Arkansas River to the divide up to Montana, and the 1848 Treaty of Guadalupe Hidalgo with Mexico that brought in everything from the south bank of the Arkansas around the San Luis Valley, west slope, out to California. Now, when I was a water attorney, 17 years I served as a water attorney for the Northern Colorado Water Conservancy District, the 7 counties of northeastern Colorado, till Governor Romer put me on the court 18 years ago, May 1. I'm your senior justice. Our Colorado Constitution removes us from politics. We are nominated by citizen nominating commissions appointed by the governor, and then we stand for retention on a yes or no vote. We don't have to spend a minute thinking about politics. We don't run for office. We don't donate to political campaigns. We can't accept any money. So I have to go do a county judge Charrett nominating commission in Sterling at noon. That's why I can't stay for the whole symposium. But the commission, the 7-member commission, 4 non-lawyers and 3 lawyers will meet this afternoon, interview candidates for this county job in Logan County, and then 3 names will be selected, and the governor within 15 days appoints a person. So that's how we do it. Then you stand for retention on a yes or no vote, and you have a term in office. So it's true that my second term of 10 years would expire in 2019, but I must retire at 72. So I'm going to leave in August of 2016. The Constitution says it's 72. I must make room for somebody else. Water disputes can be political, as you know. It's a good thing. It's a good thing we have a judiciary that's removed from politics. So we have 7 water courts that have jurisdiction over tributary and surface groundwater in the state. Dick Wolf and I will get to that in our talks this morning. And we have judges, division engineers, and local water commissioners that enforce the decrees of the court. That's how we do it in Colorado. So here we are with a Wilkes map, 1841. I want to show you some of my historic map collection, which I've donated to the Colorado Supreme Court, along with my water books and Southwest history collection. So Wilkes is the second expedition chartered by Congress after the 1803 Lewis and Clark. So here we got 1841, Wilkes is coming up the west coast surveying all of this land that actually belongs to Mexico, and then up in the northwest is contested between Russia, Britain, and the United States. Not an inch of this soil that Wilkes is surveying on the coastline belongs to the United States yet. This is 1841. 1846 is the Oregon Treaty where the Northwest comes into the Union, and 1848, as I mentioned, is the Southwest, the Treaty of Guadalupe Hidalgo. Yet here we go, the United States has some stirrings in its heart, sea to shining sea. It wants to fill in the continent. So as you will see, these military people, these Navy people, these Army officers are sent out to map the regions that actually are contested and owned, arguably, by other countries. So notice the Wilkes map here. He's got the survey correct of the Pacific coast, but he knows nothing about this great interior part of the Rocky Mountain West that we love so well. There's a little notation up here on the left-hand side that says there are streams here, but we don't know where they come from or where they go, and there's nothing here but a bunch of miserable Indians. That's about a direct quote. That was the non-Native American view of who was here. Folks that didn't understand the potential this land had. Well, yes, but they also were in possession of it from sea to shining sea. So the Colorado River is way out of line here. The Poudre River is up on the very northeast corner here. They knew about the Poudre River because the fur trappers and traders came through there. So the vast unknown, this isn't that long ago, folks. This isn't that long ago, 1841. Nothing is known here about the great interior West. All right, so there's Mexico before the Treaty of Guadalupe Hidalgo, and it takes in at least half of Colorado, all the way to the Pacific coast. That great Southwest that we love so well. This is the 1848 Fremont map. Now, this is very important to all of you. This is our backyard here as we meet in Ray, Colorado today. So in 1841, John C. Fremont, also known as the Great Pathfinder, he's a member of the Army Topographical Corps, the Surveying Corps of Engineers. He comes up the North Platte, and he gets to South Pass. And in his journals, he claims to be the discoverer of South Pass, which is a ridiculous idea. It was well known to the Native Americans and to the fur trappers and traders. It's the low point in the whole of the Continental Divide. It's the area through which the Transcontinental Railroad passed. Otherwise, the Rockies were a great barrier to get out to Oregon and California. So Fremont, by 1845, has 3 surveys of this route up the North Platte into what is now Wyoming, and then down the Front Range. Now, you remember Stephen Long came out in 1820, but it was in August, and the snowmelt had already passed, and he saw what a dinky river the South Platte was, because it had passed out of the state and downstream. So Fremont in 1843, he comes down the mountain front and in the spring snowmelt, and he says, my gosh, there is water here that can make these plains fertile, and there is a great settlement possibility here for Colorado. He completely blasted away the great American desert myth because he saw the snowmelt, and he saw all this land that could be irrigated with the snowmelt. So it was the Fremont Journals that were actually authored by his wife, Jessie Hart Benton, the daughter of Senator Benton of Missouri. She had quite a literary flair. So remember, the women of the West, lots of times, are the sticker along the fabric in the back of the backbone. And especially in Fremont's situation, he had an eloquent wife who was writing up his journals. So notice it's mostly Indian territory, right? The Pawnee, the Sioux, the Arapaho and Cheyenne, and down here, the Comanche and the Kiowa. Now, Bent's Fort is on the north side of the Arkansas, as you know, was on the Santa Fe Trail, the watered route. There was also a dry route cutting off towards Santa Fe, but if you wanted some water along the route, you went along the Arkansas on the north side. Bent's Fort stood on the north side, and then you went over Raton Pass into Mexican territory. Well, Fremont's got it all surveyed in 1845, this route into Santa Fe. In 1846, the Mexican-American War breaks out, and the map is already there. I'm going to call it the invasion map. The map is already routed. For the military. Now, go to this next one here. I want to orient you to the lower basin here. 1858, another lieutenant, Joseph Christmas Ives. How's that for a middle name? Joseph Christmas Ives tries to take a steamboat up from the Sea of Cortez, up the Colorado River, to prove that it's navigable. He proves the opposite. They wrecked the steamboat at Black Rocks, where the Hoover Dam now stands outside of Las Vegas. And so Ives and his party are on their feet. Maybe they had horses because they did have a Navajo guide. They got to the south rim of the Grand Canyon, and Ives writes in his journal, "No white man shall ever come here again. It's so desolate and barren." He's standing where the El Tovar Hotel stands today. He walks over to the Hopi Mesas, which are on the right-hand side of the map, the three mesas where the Hopi live. The oldest continuous village habitation in North America is Orabi on a Hopi Mesa that goes back to the 1100s. He discovers that the Hopi are irrigating. They're irrigating with an ingenious system of ponds, cisterns, and ditches their corn, squash, melons, and beans. To survive in this land, people have always had to practice smart water conservation, including storage. 5 reservoirs have been discovered at Mesa Verde that the ancestral Puebloans operated between 780 and 1180 AD until the third great drought, where they evacuated southwestern Colorado in 1280. There was not enough water to grow the corn or feed the turkeys that they had domesticated as a food source, and they moved south to the Hopi Mesas and the Pueblos, and then down into Mexico. So water working is a part of our heritage. Now, you've got this Colorado River Basin, you know it well, the upper basin states of Wyoming, Colorado, Utah, New Mexico, Arizona, Nevada, California, and then the Republic of Mexico, and Colorado delivers water at the border from its sources, the Rio Grande and the Colorado River that also goes to Mexico. I wonder what that was. Okay, this is the land office map in 1902. Now, this is my primary teaching tool, and I'm glad that I was able to donate it to the Colorado Supreme Court. But this really shows who we are as Coloradans. Take a look at you out here in the 1/3 of Colorado that's on the eastern border. Now, you're the closest to our neighbors up here. You see Nebraska, you see Kansas, you see New Mexico, and you see Utah. Those were the 4 territories out of which Colorado was carved in February of 1861, the outset of the Civil War. Lincoln's been elected president. The South sees the handwriting on the wall. He's opposed slavery. Now, the whole crisis of the Civil War was whether the new Western states and territories brought in by the Louisiana Purchase and the Northwest Treaty and the Treaty of Guadalupe Hidalgo would be slave or free. You remember the 1820 Missouri Compromise, dividing North and South, slavery on the South, free territory on the North. 1854, Kansas-Nebraska Act, the settlers of the new states and territories can vote whether to be slave or free. Bleeding Kansas, you know this, Kansans who are here today. How many Kansans are here today? Kansas is contested between those who want slavery and those who want the free soil status. 1857, the U.S. Supreme Court says that blacks are property. They'll never be citizens. They can be taken anywhere as property in the new Western states and territories. This blows the lid off. Lincoln is opposed to that. He runs for the presidency and is elected. He's a free soiler. What is a free soiler? People that want their own land to have a farm and not be in a slave economy. So Lincoln runs on 3 great platforms: the Republican platform of 1860, the Homestead Act, the Railroad Act, the Land Grant College Act. They're all enacted in 1862 in the Union Congress. They make us what we are. They make us what we are. There he is. Now, the downtown streets in Denver, Lincoln, Sherman, Grant, Lincoln, Sherman, Grant. You got the idea? Free soil Republicans. The first job we had as Colorado was to hold off the Texas Confederates from invading the gold fields. We were carved like this to hold the gold fields for the Union. Gold had been discovered in 1858. The 1859ers came out here en masse looking for gold. The divide comes out of Wyoming, takes the bend at the Collegiate Peaks, goes down towards Silverton, doubles back to Wolf Creek Pass. Dick, named after your cousins, right? Yeah, and goes down into New Mexico, all right? So all the potential gold-bearing area was put in one Union territory. Our farmers and miners put down their picks, shovels, and sluice boxes, volunteered to fight the Confederates who were invading up the Rio Grande. Our Colorado militia bagged their wagon train at Glorieta Pass, destroyed their ability to make war and to capture Colorado territory, and sent them back to Texas. Since that time, they bought back Crested Butte. They are part of us. But we beat them back. Imagine what might have happened with the Civil War had the Confederates controlled the gold fields. Well, it didn't happen. Now, what did we get as a result of being carved like this around to take in the Continental Divide? We got the headwaters of the four great rivers: the Platte, the Arkansas, the Rio Grande, and the Colorado River Complex. And yes, the fifth, now I don't know that I can call it a great river, but that river basin that you all are from, the Republican, right? All of that, well, of course, not all the Republican, because here's the problem. We share these interstate streams with the downstream states. So let me get to the 1902 dispute between Kansas and Colorado. Kansas's agricultural economy is growing. Now, they're a riparian water law state. What is the riparian doctrine? Under the Eastern and English common law, only those who own land on the bank of a stream can divert the waters of the stream. And you can only divert it so that you have a de minimis consumptive use. It's mostly for water power, flour mills, sawmills, other things that depended on water. And you had to return the water to the stream through a mill race because your downstream landowners had correlative rights to the same flow in the stream that you enjoyed along your property. This is the riparian law. Well, it can't exist beyond the 100th meridian, which goes through Nebraska, right? The 100th meridian, because the annual precipitation falls off to less than 20 inches, which is what you need to grow crops on a reliable, sustainable basis, except for you brave dryland farmers who take what there is. But for a sustainable agricultural economy, and you know the miners that came in here, it's rumored they like to eat. And on their heels came the farmers who dug the direct flow ditches in the tributaries and the main stem of the Platte and the Arkansas, and wherever else they could find a running stream. So they're spreading out the water on the land. So Colorado, in the first territorial legislature, passes a Land and Water Act, as you can imagine. They needed to know how they could use the water resource. Starting in 1861, we depart entirely from the riparian law so that the people along the banks of the stream cannot control the water resource. Now, there are two features of this 1861 Act. First of all, it only mentions agriculture. It says you can divert the water from the stream to wherever you can use it for agricultural use. And you have a right-of-way to cross the intervening public or private land so that you can move the water across the property of somebody else to use it where you need it. The law of beneficial use, the law of necessity and use sharing of the public's water resource. In 1866, Congress ratifies what's already happening in Colorado and the West. It says that the states and territories can adopt their own water laws to allocate the unappropriated water on the public domain. Now, what's the public domain? All the land brought into the United States by the Treaty of Guadalupe Hidalgo, the Louisiana Purchase, and the Northwest Treaty. All of the Great West is public land. In 1866, Congress severs the water on the public land as a legal interest from the land. Hang in there with me now. So the homesteaders under the 1862 Act, if they stay on the land for 5 years, they go into a land office, a location, and they're on these red dots on the map. The closest one to you where we are today was in Sterling. You would go up and you'd prove up your claim that you were on 160 surveyed but otherwise unoccupied acres. You lived there for 5 years, and then you got the patent or title to the surface. What about the water? No water came with the land, with the homestead. Because in the 1866 Mining Act, Congress severs the water on the public domain and makes the unappropriated water available to the new states and territories to allocate, manage, and administer. So you had to go through your territorial or state law to get a water right to put the water on your land. So many of you know that today. You can't be secure that the water right has been conveyed with your land because it can be taken back out and reserved and sold or used or, pledged elsewhere. So I keep trying to explain to real estate agents they better be careful in representing whether or not there's a water right for the land. So our 1876 Constitution, we're the centennial state. What's that the centennial of? The Declaration of Independence. Lincoln ran on all persons are created equal under the law. We are the centennial state looking back to 1776. We have a proud heritage. So the basic doctrine of water in Colorado, all water, surface water, tributary groundwater, which is water generally that will migrate to the surface stream within 100 years, or the depletion of which will affect the volume of the surface stream within 100 years, is subject to the Colorado Constitution's provision, 1876, that the waters of the natural stream are subject to allocation and administration by the doctrine of prior appropriation. Didn't say surface stream. It said natural stream, the waters of the natural stream. So we recognized early on in the court cases and in the Colorado Code that tributary groundwater is a part of the natural stream. And remember that our senior water rights were built as direct flow irrigation ditches along the Platte and the Arkansas and tributaries with 1860 rights, and they kept building these ditches throughout the 1800s, so that at the turn of the century, there was actually more ditch that had been built than water supply that existed in an average year, given the precipitation. The compacts aggravated this, and the equitable apportionment decrees. So I keep coming back to Kansas v. Colorado. In 1907, the U.S. Supreme Court comes down with its decision. Now, here's the cards that were put on the table for the U.S. Supreme Court. Kansas said, we were Colorado. 1854, Kansas Territory is formed. It goes up the Arkansas to the divide. The division line between Nebraska and Kansas was the baseline. We know it as Baseline Road now in Boulder. That was the dividing line between Kansas and Nebraska territories. Kansas was a riparian water law state. So it claimed in the U.S. Supreme Court that the flow had to come out of Colorado essentially undiminished. right? Colorado's response in the briefs to the 9 justices was, we are a prior appropriation state. Can't you all see this? This was in our 1876 Constitution. We get what we need, you get whatever's left. Don't worry, there's return flow, you'll get it. Kansas wasn't real happy about that position. The third great actor was the Bureau of Reclamation. In 1902, the Reclamation Act had just been enacted by Congress, and the Justice Department lawyers, being the sharp lawyers they always are, looking out after the federal interest, claimed that all the unappropriated water as of 1902 in the West was reserved for the sole use of being divvied up through reclamation projects. There weren't going to be any new water rights available anywhere in the West that the U.S. Bureau of Reclamation didn't help to develop. Well, in the court decision of 1907, the first claim that the U.S. Supreme Court throws out is Reclamation Act's claim, the government's claim. They pointed at a provision of the 1897 Organic Act and the 1902 Reclamation Act, which has a state water rights savings provision in it. Because the Western senators and representatives of all people recognized that water arising on the public domain and the forest land and the BLM land and elsewhere was needed to be made available to the farms and the growing cities. You know, our history is that the first agricultural water use that was ever mentioned as a water use then springs into giving rise to the great cities and our commerce. That we came directly out of the farms, all of us. I saw this last night on a beautiful moonlit night, and I'm seeing these farms on here saying, oh my God, this is where Colorado originated from. People settling the ground and hanging on like this. What about the groundwater? That's not allocated necessarily by the doctrine of prior appropriation. But what did the U.S. Supreme Court decide? It basically threw out Kansas's claim, and then it threw out Colorado's claim after it had thrown out the United States claim. So they're saying, no, the interstate water isn't allocated by riparian water law. It isn't allocated by prior appropriation water law. It's not going to be allocated by the Bureau of Reclamation. If the states have a dispute among themselves, they can come here and file a suit and we'll figure it out. We'll have an equitable apportionment. Now, what is an equitable apportionment? It's what 9 members of the U.S. Supreme Court decide from time to time how they're going to divide the waters. This was totally unsatisfactory to the people of the West, especially of Colorado. They wanted to be able to plan for the future. They started entering into these compacts. Our great architect of the compact was Delph Carpenter, a first-generation descendant of Union colonists. We now know it as Greeley. He was a member of the Colorado Senate. When he got voted out of office, his colleagues turned to him in a bipartisan fashion in 1911 and said, you be our negotiator, you be our litigator in the U.S. Supreme Court on these equitable apportionment cases. Try to negotiate something for us. He came up with the Compacts Clause of the United States Constitution, which had been used by states in the East to adjust boundaries when rivers changed course. We've seen that in northern Colorado as a result of the floods, right? Rivers changed course. Well, in the East, that was happening, and taxing districts and congressional districts were getting whacked, right, when the river changed course. So the Compact Clause was used by the states to fix the boundaries, regardless of which way the rivers would move, because the original settlement had divided states largely along rivers in the East. So Delph Carpenter's great contribution is he takes this constitutional provision of compacts and he applies it to water, and then proceeds to negotiate a majority of the existing 9 compacts we have today, allocating the sharing of the waters of the interstate stream. Now in this, ironically, finally, Colorado and Kansas enter into a compact in 1948 after 3 rounds in the U.S. Supreme Court of disputing what the equitable apportionment was. And then because we weren't regulating the tributary groundwater wells in the Arkansas River to comply with the provisions of the 1948 compact, we got sued by Kansas and lost in the U.S. Supreme Court. 22 years of litigation with Kansas, but we won. How did we lose and win? Well, Kansas wanted $175 million in damages for all this water that they were deprived of all those years. And our lawyers and the Attorney General's office and David Robbins, who was litigating for the Attorney General's office, got it down to $34 million. And Colorado declared victory. Well, the farmers that benefited by taking that tributary groundwater that was connected to the Arkansas didn't have to pay a dime. When a state violates a compact, the state is responsible for that violation. So the state treasury paid that damage claim to Kansas. So now just to remind you what the background of these rules and regulations are that Dick Wolf was going to talk about it there. How's that for a cold potato? Warm it up for him, Dick. We've got to regulate the wells that intercept or deplete water that would otherwise go to the service stream that contributes to the flow that other states are guaranteed under these compacts. Regardless of, now here's the punchline, regardless of when the compact is entered into, it controls the amount of water that each state has for its development and consumption. So even though we had 1890 water rights, right, when the Arkansas River Compact came in 1948, all the water rights within Colorado that are connected to the Arkansas River surface water and tributary groundwater can only deplete that amount that Colorado is entitled to. So that Dick and his division engineers have to deliver according to the compact, and all these compacts have different terms. Take a look at the guide. They have different terms because they were negotiated with the other states, and then they had to be approved by Congress. Now, the Republican compact is very interesting because the Roosevelt administration refused to have Congress get and approve the first version of it. The Justice Department lawyers were having some problem with this. You all, your predecessors, were claiming that the water is non-navigable. I think you're absolutely right. The Justice Department attorneys wanted to consider it navigable, so they would have federal jurisdiction. So, you know, there was some massaging done, and then the Republican River Compact went into effect. And I hope, Dick, you're going to address the stipulation, the arbitration, the other things that where Colorado's moving towards compliance. Now Kansas and Nebraska are picking on each other more than they're picking on us, right? I hope. But that's all right. We manage our groundwater. Nebraska has a problem with this. You know, they have a problem that they're going to have to confront, in my opinion. This is happening throughout the West. Colorado's ahead of the game. We've learned the hard way that these are integrated water resource, the surface water and the tributary groundwater. Now, we do have other kinds of groundwater, and we have a case in Colorado that depends on the federal Congress's action so that all water, wherever it's found in Colorado, is the property of the public. Now, the non-tributary groundwater and the designated groundwater and the Denver Basin Aquifer groundwater are not allocated by the prior appropriation doctrine. They're considered to be, let me put it this way, that they have a de minimis connection to the surface streams. And therefore, we have this program of the Groundwater Commission, 8 groundwater management districts. You've got the High Plains district here, right? And allocating and administering that water by a modified doctrine of prior appropriation that controls the amount of, I'm going to call it mining of the aquifer, trying to hold it down so that the resource isn't totally extinguished, a management scheme by a commission. The non-tributary groundwater under Colorado law is allocated to the overlying landowner to be pumped at a rate of 1/100th a year, So this is the non-tributary groundwater outside of the designated basins. So that doesn't guarantee that you have a 100-year supply under your land. It just says that you can only pump it at 1/100th a year. That is to conserve it somewhat, but to recognize, though, that when you pump it, it's fossil groundwater, it's gone. It's not renewable. The Ogallala aquifer, we are told, is somewhat renewable, somewhat rechargeable. That differentiates it from this real deep groundwater. For instance, Douglas County, 95% of its growth is on this fossil groundwater that's in the Denver Basin. The Arapahoe aquifer is about 2,000 feet down, is the most productive aquifer, and most of Douglas County has been built on that non-tributary groundwater. They're now looking for renewable water resources. Good luck. Okay? So the Denver Basin aquifer, the non-tributary groundwater outside of the designated groundwater basins, the designated groundwater, and the tributary groundwater, all right? 4 classifications of groundwater that have significant differences in water management attached to them. The legislature has a lot to say about what happens to the water that's not tributary groundwater, because the Colorado Supreme Court case in 1983 by our predecessors on the court basically says the General Assembly has plenary jurisdiction to decide how to allocate water that is not tributary groundwater or surface stream water. I've run through that pretty fast, but I think that may be helpful to you. Now, understand that return flows from first uses are very important to the building up of prior appropriation water rights up and down the streams, right? Agriculture consumes about 50 to 60% of the water put on the land. The rest of it is going back into the tributary groundwater system or overland through a tailwater ditch to the stream. And we banked our water rights in priority, and we're an adjudication state. So you can have an old water right based on just appropriation, but if you don't get in and adjudicate it, you are continually postponed until the year in which you seek the adjudication or get your permit. You with me on that? I had a client, very well-known Northern Coloradan, who came to me in 1985, and he wanted me to get a decree, a priority date set for a water right that his father had developed in 1920. Well, I told him, well, it's 1985. I can file you an application by the end of the year and you'll get a 1985 date. And within that year, then your true appropriation, starting at the time your father started to use the water, can be recognized within that year. But you have to understand that as of the 1903 Act of the Colorado Legislature, you had to come in and adjudicate your water right. You had to come in and get a court decree from it, not for it. Now I'm talking about surface water and tributary groundwater rights, okay? So you had to get a decree for it that sets the point of diversion, the amount of diversion, the type of use, and the place of use, okay? Those are the 4 incidents that are put in the decree. And then if your decree is going to injure another water right, then if you want to be not subject to curtailment by the state engineer, the division engineer, and the water commissioners, then you have to have a substitute supply or replacement augmentation plan to replace the depletions to the stream that would otherwise occur to the senior, mainly surface ditches with those early dates, because well depletion causes cone of depression and has lag time to the stream. The amount of water that was taken, consumed, and used, the effect on the surface stream can be felt years later. Well, that's the time those ditches are in priority. They're going to be injured, so that a substitute water supply or replacement plan provides water from other sources, reservoir water or water put in the ground through a leaky ditch or unlined pit. Perish the thought, right? Huh? Conservation. Smart conservation is taking a leaky ditch and replenishing it off irrigation times and getting recharge credit. The farmers themselves invented this, right? It's it horrifies environmentalists, you know. Our inefficient diversions and use actually sustain many water rights downstream, you know, that depend upon the return flow from prior uses, from cities and from farming. So watch out, you know. People don't understand this. They come along the Front Range and they settle, they come in from California or Texas and they see this ditch coming through the backyard, right? And what are the two things they think they can do with the ditch? Use the water or fill it in. What are the two things they can't do? Use the water or fill it in, you know, unless they have a share in the ditch, you know, an interest in the water right. We have these cases in this new century. We had this high-tone fishing and hunting club up there in Pitkin County, you know, outside of Aspen. And they built these structures. They filled in the ditch and built all these structures. And, you know, they thought they were doing pretty great, you know. Of course, they had to have a real good membership fee to get on there and use it. Well, the downstream ditch owners took exception to it. They went to water court over there in Water Division 5, and the water judge ruled, take those structures off, restore the ditch. What did I say about the 1861 Act? You have an interest in the right-of-way to get your water to your land, to operate and maintain it, let alone construct it. And your water right arises from actual beneficial use of the public's water resource. The two incidents of being able to use this water that was severed from the public domain. So what we do at the Colorado Supreme Court, by the way, these cases from the 7 water courts come directly to us. They bypass the Colorado Court of Appeals. What other type of case bypasses the Colorado Court of Appeals? Death penalty cases. You got it? Water and death. Huh? So the water cases come directly to us, and we uphold the water court, said, restore the ditch. Take off those structures unless you can get an agreement with the down ditch owners who are being deprived of their right-of-way and of their water right. If you can get an agreement with them to put a pipe in there, deliver their water, and let them come on if you can't maintain it, operate it. And by the way, you have to, because you altered it, pay for all the costs of that delivery that's now going to be required out of whatever alternative arrangement you can have, or simply restore the ditch. So we take these cases very seriously, the 7 of us on the Colorado Supreme Court. In that year, 2002, 2003, unfortunately, a lot of those wells that were sunk in the tributary aquifer of the Platte had to be curtailed to the call of the senior service ditches because they didn't have replacement plans in place. Some ditches did have replacement plans. The 1969 Act clearly allowed people to get augmentation plans decreed in the court for out-of-priority diversions, which supplied substitute water so that the state engineer didn't have to enforce against them. But the 1950s drought, the invention of the high-capacity irrigation pump, and rural electrification made these water resources pretty attractive in dry years. And we didn't get control of it later, but the cases and the legislation is absolutely clear. Every time the legislature spoke to this point, or the court spoke to it in the 1900s, a well permit does not give you a water right. A well permit is an authorization for the diversion. Like the service ditch is a diversion, the well is the diversion. Granting a well permit doesn't grant the water right. The water right under Colorado law is accomplished by need and use, okay? So we often get confused. In that crisis year, 2002, 2003, I was up and down talking to forums on the South Platte about that concept. Just because you have a permit didn't mean you weren't interfering with somebody else's water right, and it doesn't mean you didn't need to get your water right adjudicated. The 1969 Act had a provision, a 2-year savings provision for coming in and adjudicating your water right and getting the true appropriation date. If you didn't act within that 2 years, and I think it was actually extended 1 more year, there was a total of 3 years, then your appropriation date was postponed to when you came in to get it adjudicated. That's a quick overview, sobering overview maybe. There's Dick's famous snake diagram. That shows the water flows on an average statistical basis over a number of years of deliveries out of state under the compacts. Notice the puny plain streams, huh? 85% of our population is actually east of the divide. 85% of our water supply is west of the divide. 70% of the virgin supply of the water at Lee Ferry, the dividing line between the upper basin and the lower basin states, is contributed by Colorado. But here's the punchline. We can only consume 1/3 of the Colorado water that our mountains and springs and tributary groundwater produces. We can only consume 1/3. Why? 2/3 statistically, averaging it now, have to be delivered out of state. So we're subject to two big constraints: what Mother Nature provides us in any given year and what the interstate compacts limit us to. So think about this sobering thought. We have 5 million people today. We're supposed to double within the next 50 years. We got the same basic water supply the ancestral Puebloans and the settlers of the High Plains had, right? And we have this new population that we're trying to figure out how to serve. So conserve, 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 preserve our rural areas, try not to have massive migration of permanent water transfers to cities, leasing, crop rotational fallowing plan, all these other tools that the legislature is coming up with, some way to share the water among ourselves and be smart about it. That's what you're all about today on one of the most scarce and precious resources known or unknown. We need to educate the rest of Colorado about what you all face. There's the hydrograph, right, of the snowmelt. May to July, you know. Stephen Long came after that. Fremont saw it. There's our whole potential. That's why we store water in Colorado. We have 2,000 reservoirs, large and small, so we can take part of that peak and manage it like Joseph and the Pharaoh. They were storing grain in the times of plenty for the days of want. We store water to grow the grain. What is one of the best crops in a dry year? Alfalfa. It's rumored that cows like to eat it. Huh? I often have debated people from the East, professors coming in saying, all we have to do to free up the water that we need and restore the rivers to the way they should be is to ban alfalfa because it consumes water. There's a couple things wrong with that. One, the water rights are held by people who decide themselves, not the government, how they're going to use their water. If they want to grow alfalfa, that's their constitutional right. We judges are sworn to uphold against the taking of private property without just compensation, and the most valuable rights in Colorado are water use rights. Those are the most valuable rights. So we're not going to wave a wand and have the government say, this is what you plant this year and this is how you're going to use your water. It doesn't work like that. The in-stream flow law, the Colorado legislature in 1973 has these in-stream flow water rights. They're specifically junior to the senior rights. That's the way we do things in Colorado. The new kayak course water rights that have flows so you can jump boats at lunchtime, you know, through these artificial structures that make waves. Now we have kayak course rights, but they are slotted in the priority system as well. And when one wants to change a water right from agricultural use to municipal use, for example, you can't cause injury to all the other water rights that are in the system. That's how we do things in Colorado. Our law grew out of the ground respecting the prior settled needs, use rights, adjudicated use rights of those who came before. There are the 7 water divisions, the 7 water courts. They're in major basins in Colorado. Remember, this is the surface water and the tributary groundwater. Your designated groundwater districts, you know, are superimposed on the High Plains areas. Your non-tributary water in the Denver Basin groundwater system goes from Colorado Springs to Greeley, is regulated by state engineer, well permits, and figuring out the allocation that these overlying landowners have of the non-tributary water. And there's our Trans-Mountain diversions. We could not have this growth on the Front Range and preserve agriculture if we didn't move water from the Colorado River water sources to the Front Range. The next citizen guide that's due out in July is the Citizen Guide to Colorado Trans-Basin Diversions. We're going to finally explain to the public how Colorado's backbone serves Colorado through shared use of Colorado's apportioned allotments of the compact. Okay, that's a short overview. I hope it helps. I've got to go to Sterling to chair a county judge nominating commission that starts at noon, but I can take some questions. Questions, what questions do we have?
Justice Hobbs, when the compacts were being decided upon, was there any consideration to basin-wide jurisdiction versus state-wide jurisdiction?
The answer would be no. And the reason is that only states can enter a compact. Now, there is shared jurisdiction according to some of the terms of the compact. You have a commission, a Republican Basin Commission, and there's a commission on the Arkansas. So the way the compact drafters settled these things, and there's an Upper Basin Colorado River Commission as well, is that when you have these commissions in place, then hopefully their job is to have some kind of management plans and cooperation and neighborly cooperation, even though it's real world, who gets what water when, to work on disputes and to work on implementation plans. So no, only a state can enter a compact, but when the state enters the compact, it can, with the other states and the ratification of Congress, determine what mechanisms are used there to deal with conflicts and planning and sharing shortages. Does that help? Subbasins of the state can't negotiate compacts. That was the problem when eastern Colorado was going to maybe secede from Colorado. You know, I'm a patriotic Coloradan. I hope that never happens. But there was a real issue about whether Colorado River allocation could be used in this new 51st state because the allocation was to Colorado. Serious problem. Hang with us, guys. Yeah, next question. I hope I partially got to that. Anything else?
Justice Hobbs.
Yeah.
You mentioned with the non-compliance with the compact coming from the Arkansas that the state of Colorado paid that penalty.
Yeah.
And yet, with this particular compliance issue with this compact, I feel it's all eastern Colorado that's paying for it, that the state of Colorado has washed its hands of it, so to speak. I don't
Well,
see a lot of money coming from the state to help.
I hope that's not true.
That would be how I feel.
Okay, well, talk with your legislators and the Water Conservation Board. As far as I know, there is good planning money and even financing money putting into projects that help us with our interstate compact compliance and developing and conserving water throughout Colorado. My understanding is that, you know, that the legislature is open to that. We exist in the state to help each other. Now, we do need to tax ourselves in some ways. In the San Luis Valley, the groundwater pumpers north of the Rio Grande had severely depleted the closed basin aquifer there, the unconfined aquifer, to the tune of more than 1 million acre-feet a year. Well, now they are taxing themselves so they can pay for augmentation water to replace the injury to the service stream users of the Rio Grande, and their plan is to take 40,000 acres out of production to fallow land and to pay people to fallow land. Now, if that's what you're talking about, where you're assessing yourself to try to spread the costs of having workable water rights year in and year out, I say, go for it. I mean, our legislature isn't notorious about handing out bunches of money to any cause. Actually, we have a debt restriction. You know, the legislature can't enter a long-term debt or any debt without a vote of the people. That's why we have all these local districts, all over the state, conservancy districts, conservation districts, soil and water sanitation districts, so that we can issue bonds that are repaid by taxes and revenue to build infrastructure, right? We have a lot of demands on the state level and no ability to incur debt without a statewide vote. Good luck with a statewide vote. You remember when that referendum to raise $2 billion to build Colorado water projects came up to vote by the people? They voted it down overwhelmingly. So the way we get things done is on a local level and through fees and taxes that support good planning, now augmented by Water Conservation Board construction grants and other means. I know I've just slightly scratched the surface on that. I hope you're not alone in your efforts. I hope this Headwaters magazine that we plan on having about the High Plains in the fall, if we can get it written right, will help to show what you're actually doing here to work with each other to help resolve these problems and educate the rest of the state. Other questions? Well, if you're high and dry, do it with pride. And don't forget, beer is bottled water. You have not asked me this question, but I tell you, in every Front Range city that I visit, they wonder what we're going to do with these bottled water companies. They see something immoral and strange and wrong about that, right? Then I say to them, what do you think beer is? Bottled water. Okay, what do you think a melon is? Well, you can call that a bottle. That melon is a pretty good container of water. Forget these ideas that there's something immoral or wrong. We try to optimize Colorado's water resource to stretch it for as many beneficial needs and purposes as we can. That's our law. Thank you.